vision is that if all goes well, we might be done today so that we can get this out for the next meeting. Maybe we'll see where we go. Yeah, Kim, you're looking like that's a big, big wish, right? Come on, we'll get it done. So, okay, so formally call the meeting to order. Do we have any additions, deletions to the agenda? Hearing none. We will draw our attention to the minutes of August 20th, and thank you, Kim, for providing those. Do we have any desires for the minutes?
Make a motion to accept them.
Second?
Second.
Second by the Colonel. Thank you. Any discussion? Hearing none. All in favor? Aye.
Aye.
So approved. So now we have not a lot of feedback. I was hoping Mark would be here because I think Mark and Jen held 1 or 2 joint listening sessions was what I was hearing, but I haven't heard anything back from them. The only thing that Kim shared out was, I think, a 1-line question or recommendation from Councilmember Kareem Chapman. Our labor attorney provided some content, and then we got some notes out of the RDAP meeting. Does that seem to be right, Kim?
Yes, we did not receive any feedback on the survey. And I'll quickly look if I have any notes from I was at the one informational session that Jen and Mark had done. And there wasn't a lot of feedback, but I'm just going to take a quick look to see if there's something I missed to send you out.
Okay.
But yes, what I sent to you is everything that we had, and just one note on Councilmember Chapman's email. I did reply to him that I would bring this to you all. But in my reply to him, I said that, I would imagine that, any profiling would fall under our discrimination clause, and was just explaining to him that the code of conduct wouldn't be where we could specifically name every instance of a discriminatory practice, but that I would bring it to you all in case it was something you wanted to highlight or address in a different way.
Yeah, thanks. Because that was my initial when I saw his, would it be possible to add specific language about profiling as it pertains to traffic stops? I think that, when we're talking discrimination, we're talking discrimination in any venue that a police officer might engage with individuals. So I do believe that it's already included.
And I think we had discussions around that concept and intentionally had language that was broad that would catch everything like that, rather than trying to be detailed and catch and put in little things, because you're not going to get everything if you try to do that.
Right. Yeah, you'll miss.
Sorry, I'm sorry to interrupt. I just think it's important for him to know that maybe in reflection back, that was certainly part of our discussion. We did encompass profiling, and there was extensive conversation.
Yeah, I need to talk with Kareem anyway later this week on professional regulation stuff. So I'll make sure to connect personally with him and let him know that we received that, discussed it, and that there was intentionality beyond our original construction of this, and it was to include that. Okay. So now I don't know, certainly the most comprehensive, I guess, or maybe I'm just visual, the easiest for me selfishly is to maybe take up each of these kind of recommendations, overlay them to what we have, see if there's any desire, we see any need to make any changes based upon recommendations. Does that seem to make sense?
So, Trevor, can I add one thing before we get there?
Oh, yeah, please.
Just something simple that on a positive note, we did review and discuss this at my board meeting, the Troopers Association, and our board voted to support the code of conduct as it was presented to them.
Probably has something to do with their leadership. I don't know, the director. Thank you. That's nice. Yes. Yes. I mean, that's a huge stepping off point, and hopefully that's why I guess I'm maybe too optimistic that we can narrow down to something that we want to move forward. So I'm going to start looking at selfishly, I guess, just because it's visually the easiest for me, what came out of our attorney's hands. I don't know if you want me to do screen share, if everybody has that. Better yet, I think I'll just take prerogative here. I'm just going to do screen share. Then we are all looking at the same thing. So Julie McKenzie, who is pretty intense. I don't know if anybody's met her yet, but she's been with us for several months now. She was hired in as specifically a labor attorney to deal with our risk management side of the house. She has been labor attorney down at Dartmouth Hitchcock Medical Center. Before that, she was labor counsel for the town of Somerville, Massachusetts. So she has law enforcement experience through Somerville Police. But these are just some thoughts of hers, and I don't know if any of them make sense. And Kim, I know you have had a lot of investment in this, and you see it with the overlay of our council lens. So really look forward to some of your thoughts as to whether these make sense or not. The first kind of suggestion that Julie makes is that the first section here where she recommends adding in person or virtually. I don't know if that's necessary or not. I don't know if that gets too much specificity. If we leave it out, it's just assuming it's all encompassing, or if there is a need to get more specific.
My initial thought to that was, 5-10 years ago, I would want to call out virtually. Now it seems like, I mean, I'm never going to be opposed to that sort of specificity. I don't think it's ruling out some other third space. I don't know that we don't know about yet, that we're not working in. But I believe the language that we had, including conduct on duty and off duty, virtual spaces would be considered in that. So I wouldn't be opposed to it, but I also didn't think at this point in time that virtually needs to be called out, because so much of our world and landscape is in both spaces now. But I'd be really curious to hear what other folks thought when they saw that.
And I'm fine with that. And also with Mike's comments, early on about, the car stops, I think that the less specificity in some areas, I think perhaps the better we are, less opportunity for argument because we might have left something out. If we start getting specific and we leave one thing out, then we're going to have a battle later on. So, I'm fine with that. I mean, I know that there was, an example of some virtual activities. And I think as we've written this, it's my belief and impression that it would cover in any venue, any forum.
Yeah.
I'm seeing heads nod. So if we're good, we'll skip over that. I don't know here, material fact. I don't know if this was lawyer speak. I think here we were trying to make sure that there was clear nexus to the job. I'm referring to that comment box that's open now. If there's any desire to make adjustments here. I mean, this was, go ahead.
Trevor, with material fact, I mean, I forget where we pulled this language from, but there was just some recognition that the issue isn't, whether you said the car was blue and it was in fact black. That's not what we're talking about. We're getting to the heart of representations that actually have some bearing on like the outcome of encounter or something to that effect. And so I think I might have pulled this language and I forget where I pulled it from, but that was the distinction that.
Yeah, the material, the terminology of material fact. Yeah, it's to what Tucker's point. The one thing, Trevor, that's been on my mind about the untruthfulness one, is and I'm trying to think how to say this without saying something that I'm not supposed to say. Is
You're amongst friends. It's only recorded. Don't worry.
Yeah. So
talk in a big circle. We'll figure it out.
Okay. Stay with me on this little journey, everyone. So the way it's worded right now, we're limited to an officer making an untruthful statement concerning during an official criminal justice record while testifying under oath or during an agency's internal affairs or VCJC investigation. So did we accidentally narrow this a little bit too much for the scenario of, an officer lying to their agency head, but maybe the IA hasn't started yet, but they made an untruthful statement, about something that was pretty important, about an action they did, or saying somebody else did something when they didn't. If we're throwing the chief off of, hey, don't look at me, look at the other officer, that sort of scenario. Like, I did wonder when I read Julie's, Julie's wording, right, is focusing the untruthful statement, when you're in your role as the officer and or representing your employer, sorry, which definitely casts a wider net. And I know we wanted to be really careful not to get into the scenario of, you lied about whether you had dessert that day, like that's what we don't want to get into. But I was thinking, and we've had some recent professional regulation cases that I've looked at where the officer made an untruthful statement and it was important, like it mattered that they were untruthful, and I'm not sure our current language would have captured that. Like, I think they'd slide past us having an ability to sanction that behavior.
I think you're right. I mean, are there times when we want to catch untruthfulness that isn't a formal investigation? So Micah cut you off. I'm sorry.
Yeah, I think it's an issue where there's a fine line here. There's going to be interactions between employees, supervisors, bosses, where there may be issues that come up, and it's a serious question that's going to come out in an IA and be an employment matter. Did their work dispute, or however it plays out, really become something you should face decertification over? Yeah, I think we had this discussion back then, and we wanted it to be related to official conduct on these issues that we cited intentionally, because there are going to be issues that are employment matters and should stay there and be dealt with as an employment matter. They may be fired, leave their job. It's up to future employers to decide after doing a background, am I willing to hire this person? Not everything needs to end up at the council for decertification.
good point. And what I'm thinking as well is that if it is a untruthfulness in the performance of job to a supervisor, to the colonel, the chief, and that becomes an issue, then you ultimately will, in a case of seriousness, will open an internal affairs investigation where you'll ask the very same question. And then if they give the untruthful response, well, now it's heightened that seriousness. So that does make sense. And you are right that that this was seen as, for the most egregious of cases.
I hate to say, but I agree with those comments as well. Kim, I understand the rationale for bringing it up, and I do remember Mike bringing this issue up before. It was during, an official investigation, and I think to Trevor's point, even if a statement is made that is untruthful and it's not within the realm of an internal investigation or an official act at that point, if there is a legitimate internal affairs investigation done, that issue should still come out.
I mean, I've seen these situations in internal affairs cases that resolve them. And they may not face termination over it, may face some discipline, but when they went into the IA investigation, they were honest about what the issue was, and it does get resolved. That's where these things should be worked out.
Yeah. And I think it provides that opportunity to point out the seriousness. If you made that untruthful statement, but now we've upped the ante, it's a formal investigation. Now's your chance to own it and deal with it internally, or it moves to an external process if you don't want to clarify. Yeah. Okay, so I'm going to move beyond that. Discrimination. I know we had a lot of discussion around this course of conduct or single act. I'm not sure removing those changes the meaning a whole lot. I think I recall a lot of discussion about that specific wording. I don't have any heartburn with it the way it's written, but wanted to just offer this up for opportunity to think about it.
Trevor, is Julie's comment for the "I don't love this," is that connected to number 2 or number 3?
That will be this. I'll highlight the area. This area is what the comment pertains to, and we're not there yet.
Okay.
That's the "I don't love this" comment. Right now, I'm up here. Yep. So two more things, and then we'll get to the comment. So yeah, this was just, she doesn't say why she did that. I assume it's just simplification of language, just so it was clear it covered all conduct. I think here we're specifically looking. I mean, I don't know if the meaning changes. Go ahead, Karen. Sorry, I'm not good at watching the little hands. So just
Kim, you go ahead
Kim's hand
first.
is up too. So
Kim,
sorry, I couldn't see.
as
Karen.
always.
Just speak up.
So between Julie's version and the RDAP meeting that I attended, the RDAP meeting, this second clause received a lot of attention, and the overall feedback was, this is really long and confusing, and there was feedback about the course of conduct or a single egregious act, and a suggestion as well to simplify it to just conduct. And one of the comments was, with this language, which is, language pulled from employment law, so it's not like there aren't definitions for course of conduct or single egregious act. But the question was, like, do you really need that? Like, do you need to then say, like, this is egregious versus this if it's a single act? Like, it is putting an extra step there. And is that the intention of the subcommittee, and or it's a course of conduct? What does course mean? Have you established that there was a course of conduct? How many times is a course? So there was feedback from RDAP as well on this. And from my perspective, it is an easier statement to say conduct. And then, it's brought to the committee and the council whether that conduct is biased or not, and we're not getting into, well, is this a single egregious act or a course of conduct conversation? It just takes that piece out.
Well, I might look at it differently. In my experience, I'm a person coming in from the outside. I'm a community member. We've had a number of instances over several years where there actually was the need to raise this idea that some things that we should be looking at really specifically at course of conduct. And that this idea that because what happens is we focus on that single egregious act and we don't notice all of the things that have happened to get us to that single egregious act. So I'm just going to say I would be in favor of leaving the language as is. And it may seem like this is long, and it is taken directly from employment law. And in this case, I don't think a little overkill hurts. I think we have to actually be pretty explicit and pretty fierce in our description of what it means to be in right relationship with people who are different from you as a law enforcement officer. I think it's really important. And I know as a member of the Professional Regulation Subcommittee, we've had a couple, maybe even more than a couple of moments where we didn't have we could see that there was discriminatory behavior happening, but we didn't have the language or the standard to go by to really name that. So that my 2 cents.
One response to that, Karen, is that my understanding and my reading, and Tucker or anyone else, correct me if you think otherwise, if it said conduct, like course of conduct or a single egregious act would fall under the umbrella term conduct. Like if it's conduct, if we saw something that was multiple times, you know, low level, multiple time behavior, that would fit under conduct. Like we don't need the word course of conduct to fit that, if that makes sense. That would be my reading, but if that's...
I'm not going to die on this hill. There are other hills to die on here, but this is not the hill I'll die on. And so I can appreciate that, and we'll go with the will of the group.
So if memory serves, I think when we were talking about this last, some stories came out, and so like the single egregious act is George Floyd. Like that's an obvious one. That's low hanging fruit in terms of saying like we're talking about the big thing. And then course of conduct, I'm thinking like stalking investigations, like I forget, was it Justice Stewart or Potter Stewart saying, you know it when you see it. Sometimes stalking isn't always the boogeyman in the bushes, but rather it's stuff on Facebook, it's driving by places of work, it's doing stuff with phone records or accounts or whatever it may be. And so I personally like the course of conduct, and I understand Kim's definition there. I think to the degree that the word conduct is the umbrella to these two terms, I like the fact that these are subterms, not entirely of conduct, because I mean, I've received complaints that employees were discriminating against people when we reviewed body-worn camera footage. What we saw and what we talked through the complainant with was, no, they were performing a DUI investigation, and it just so happened that the driver happened to be of a different race. They weren't stopped because of the race. Here's 15 other car stops that preceded this stop, and they were all performed the same way. So we could identify in this one complaint that there wasn't a course of conduct, and they were generally performed following standard training, standardized field sobriety tests, same questions, same pattern of behavior, versus a scenario where I could see the 15, making this up, the 15 white drivers were treated one way, and then the minority race being stopped and they're treated an entirely different way. Well, that might be something that we'd want to look at. And so I don't know if that fits this language or if conduct is better to it, but the concern I do have is that we do receive complaints that people are exercising bias, and whether implicit or explicit, those are things that agencies need to deal with, and maybe the council needs to deal with through certification issue. But the volume of it is also perception, and sometimes perception doesn't meet what we're teaching people to do as law enforcement officers. So this is where I get concerned with this section. And then a second place I get concerned with this section in its entirety, I do agree with many people, and Karen, I'm hearing you loud and clear in terms of fighting fiercely for the way it's written. But on the other side, this is the most confusing one. This is the one that, while we haven't heard from the profession strongly about it, I think it's also similar to the fair and impartial policing policy. Sometimes it's just people don't understand what they're even reading. Most of this document is written to be a layperson's document, and I think this is the one that's the most legal speak. So just throwing that out there for thought, but that's where I'm at.
Yeah, and I don't see it so much as legal speak. I mean, this just covers a lot of potential situations where people might be discriminated against. I mean, it's verbose. There's a lot of examples here. You can't do this, you can't do this, you can't do this, you can't do this. I mean, certainly you could put, you can't discriminate based upon any protected characteristic under law. That would say it. But I do think that there's some value in articulating out and reminding people of, hey, be cognizant of these things, because although we should, I'm going to guess that there are very few people that know all the protected elements under law, all the protections that come. So I think that I see some value in listing out, albeit it does make it verbose. I'm sure I have a challenge with it. Karen, you're hand up, hand down.
I'm going back and forth in my mind.
Yeah.
I wonder if there's I hear what everybody's saying, and there are places where I get a little bit lost in this too. Further down into the paragraph, so I'm just wondering if we do something similar to what we did with domestic violence and we make a reference to the model policy. Because we have a model fair and impartial policing policy.
We do, and I'm not sure, Julie, that's why she put that in or policy, but she does recommend adding or policy to that clause. Maybe it is more simplistic, Mark.
I mean, I think the framing language, I don't have it right in front of me, says that a violation of this code of conduct or state mandated model policy. Mm-hmm. So is this necessary?
Well, I
think it is. I think it is
similar to DV and criminal conduct. Yes, we have those covered, but if we're saying these are that this is not only for professional regulation, but this is a value statement of the profession, I think you'd want something in it. But and I made a similar note when I was listening to RDAP, would we want a simpler statement, about not performing in a biased fashion and then a reference to the policy? I did ask myself that question too, Karen. And I'm not sure.
Yeah, Karen, you can mark this day. I'm agreeing with you here. Mark this day. Awesome. I think that simplifying this to say, I'm stream of conscious here. I shall not engage in explicit bias, and maybe will endeavor to discover and acknowledge my biases and work continuously in good faith, blah, 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 in accordance with the fair and impartial policing policy. I'm not saying that there's language in here that should land in the FIP policy that isn't there. I'm going off memory right now, but I think the point is we could simplify this and basically say follow FIP. If FIP needs some updates, we could do updates in FIP. And basically, I'm not going to do discrimination.
Karen, please.
Mark, thank you for all of that. I'm also noting that the last update we made to the FIT policy took 2 years. So let's, remember that. I think that I do think that it's important that everything that's in this policy is really accessible to any law enforcement officer in the state. So it has to be written in terms that even I can understand. What I would love it if we could find that balance between, like being explicit. I'm thinking about Kareem's comment about, can we add, the traffic stop information. So this policy is written, has a lot in it, a long list that will become outdated over time, and or the language will change over time. So but I don't want to lose the meat of it. The intention of it is around obviously not discriminating, but I want to do a lot with this clause. I want to make sure that officers understand what we're talking about, and that there are things that they could be doing that would be really obvious, as well as things that they could be doing that are not so obvious, but would constitute a course of conduct. I would also want to be able to look at this from the outside in and say, oh, all the law enforcement officers in our state understand this and they comport with it and they support it. And so I don't want to dilute it too much, because I would want to know that this is a strong statement as a citizen. And I'm going to stop talking, but I also do think the last sentence is very compelling, the one that Julie added.
Tucker, save us.
Well, I don't think it saves anyone. I was gonna say, as it relates to the last sentence, it is a nice sentence. I do think it's more as an aspirational sentence than the other terms of this policy, which we were trying to distill into concrete behaviors that would be actionable for engaging in or not engaging in. And so I do think that last sentence kind of falls more into that aspirational category of things that we'd like people to do, but it's not necessarily an actionable thing if someone doesn't do, or anyway. And then course of conduct or single egregious act, that was pulled from employment law, the thought being that we'd be using those standards as you can pull them from the employment law and as defined in employment law. That's just because they're so well kind of established there. The rest, the whole paragraph sentence here, it originally came from a regulation in Florida regarding how they defined discriminatory conduct for purposes of enforcement by law enforcement. For no particular reason, they just happened to have a clear definition down in their regs down there. And it was designed to try to bring some sense of clarity again on something that's directly actionable versus an aspirational statement on that we don't want to be discriminatory, but rather this is what discrimination is, and you could lose your certification for it. So anyway, none of those comments save anything, but they're just some general comments.
Well, I can speak to the last sentence. I appreciate Julie, putting that in. It's a visionary statement, but I'm not sure we're going to decertify somebody because they didn't endeavor to discover. So, that just I agree, Karen. It's nice. It's a kind of a value statement, but I think it's difficult, if not impossible, to enforce. So I think I would be in favor of not accepting that suggestion. Kim, I know you're busy typing here, and I'm trying to look back at what you offered.
Yeah, and I was just pulling in one of the other documents I had sent to you. I realized that in the professional regulation subcommittee procedures under the definition of gross professional misconduct, some of this had been captured and it had never come up before. So I was just highlighting this and language and this ties with Julio Thompson had made the observation at RDAP of, and let me just see if I can pull, he basically was saying, wouldn't it be better to say, that an officer would not, knowingly violate a person's constitutional rights and or, treat an individual in a biased fashion, like that we could capture, because so much of this is because you're a protected person, it falls underneath constitutional rights. Like, could we, in that simplifying it, capture it in that way? And that, so anyways, when I saw it in professional regulation that we had some of this language of conduct that violates an individual's legal rights, and then kept going after the semicolon involves the disparate treatment, we probably wouldn't want to use the word disparate. But in it, just throwing that language into this mix of the conversation.
Okay. Mark.
I'm going to be the one fighting for the aspirational statement because I actually can think of the circumstance where you can see it, complaints made against someone that they're engaging in implicit biased enforcement. And this could be pulled out of the annual submission for traffic stop race data reports. And so on average, Officer X stops more people of color and searches them at a disproportionate rate than the rest of the state. And that complaint's filed with the Professional Regulation Committee, who says, well, there's not enough evidence here, whatever. Then the next year, then the next year, then the next year. And so you can see this thing. I think there's an opportunity with the Professional Regulation Committee to say, hey, we're looking at what you're doing and we're talking to you about this behavior. And we're saying, maybe you actually need to start looking at these things. Maybe there's opportunities for training and recognizing implicit biases that they're just not aware of at the time. And this isn't necessarily intentional misconduct, but for the person who's saying, no, I'm right, you're wrong, everyone else is wrong, without that sentence or a version thereof, I don't think that there's necessarily opportunity for that reflection. Or more broadly, there's always an opportunity for every opportunity to say that there's discrimination, whether intentional or unintentional, those could be raised. I think through our fair and impartial policing trainings over the last decade, we have talked at length about anti-bias, and there's competing narratives on can you have an anti-bias. I mean, there's an argument that we all have biases. There's an argument that we want to have behavior that's not discriminatory, and I think that's all of our goal. But putting the words on paper, we're landing kind of at this at Mike's fine line of where are we trying to delineate what is appropriate behavior, what is inappropriate behavior, which I think is why this has turned into a lengthy verbose paragraph. I'm wondering if we could, because it's already been identified that we have a policy, it's already been identified that some of this is, in fact, a value statement, if we could take the sentence from professional regulations procedures to say, I will not engage in explicit bias or explicit, I guess, bias or any other conduct that may undermine the public's confidence in enforcement profession as viewed by the fair and impartial policing policy. Something like that.
Right, Tucker?
And the only thing I'll add, I remembered it, having just commented on this. One of the reasons that we drafted this with this provision, which clearly and substantially demonstrates that I cannot perform my duties, was because we were contemplating off-duty discriminatory conduct unrelated to someone's job. And so we were we were trying to capture the circumstances in which someone's off-duty behavior that demonstrates some bias or discrimination would result in potential decertification. I think that's where it's kind of coming back to me now of why we went down the second clause about clearly and substantially demonstrating. And then in terms of the comment on departments will have whole arbitrations over whether the standard has been met. I mean, I think the idea is it wouldn't be departments necessarily. It would be the professional regulations subcommittee having to parse this on whether someone's off, specifically whether someone's off-duty conduct in addition to the FIT policy, and whether that off-duty conduct rises to that level or not.
Okay, Mike.
Tucker keeps covering a lot of what I'm thinking. Thanks, Tucker. Back to Mark's point on the aspirational statement. I understand the point and I agree with the point. I don't agree that it belongs in here. We can't ever measure whether or not someone is endeavoring to discover or acknowledge their biases. There's no way of enforcing that. It doesn't belong here. We're talking about what conduct is prohibited. And I don't agree that it should be there. But your point is a very good one. If annually you're seeing the same problem with somebody, they're stopping cars, you're seeing problems with the numbers. I've said this a lot. I'm going to keep saying it. Department heads, supervisors have a job to do, and I hope they're starting to do it.
Yeah. Point. So Tucker, that helps to refresh my memory on the clearly and of substantially. And you are right. I mean, certainly agencies can, make this part of their policy, it's going to be part of our internal mechanisms, and then they can discipline to it, but they can also they'll have their own policies. So if clearly and substantially is a challenge for them, then they can write it differently if they want to do something internal. But this will be for the council. So Kim? You're muted.
Sorry, oh my God. Just to add in on that last call, that's my memory as well, Tucker. Just being very careful again to have there needs to be some space for officers to have a private life, and also we don't want to be policing thoughts. I think that was partially why we wanted to be very careful on that, to show that there was a connection to your ability to do your job. The RDAP, I just want to make sure all the feedback is incorporated. RDAP, some members and some guests who happened to be there also highlighted that language, that they had concerns about that the level of clearly and substantially demonstrates. One thing I did not get into with RDAP, just because it was a long meeting and I didn't want to start breaking down everything about our process, is I think any attorney would raise an eyebrow at that language, except for understanding that for council procedures, it's a preponderance of the evidence standard. So, that clearly and substantially is not, in my mind, a hurdle that can't be overcome, given that it's a preponderance. If we're trying to get to reasonable doubt or even clear and convincing, that might be harder, but really you're showing that clause doesn't concern me the way it concerned some others who didn't understand council process or administrative proceedings. So I just wanted to throw that in.
Tom added a note to the chat there. Is there an appetite to try to slim this down, to find another way to say what we're saying, whether it's referencing the policy? I think we're at this point probably going to be looking at the will of the majority. I don't know if we're going to come to full agreement on this or not. I get that it's verbose, but I don't personally have a problem with it. I like seeing those highlights, the things that kind of stand out as reminders, but I also can understand that maybe there's a different way to say it.
And only, again, to throw in there to make sure all the feedback's in, if we were to keep the list of examples of what are protected groups, Julio had asked, again, if folks saw the notes from RDAP, he had pointed out that, sorry, let me get the wording right, that everything that we've listed is considered status-based, like who you are, and left out like viewpoint or content discrimination type behavior. Just if we needed to add one more thing in the way this is worded. In some other areas, political affiliation might need to be added, and/or participating in a protected activity. So that's the protest example. That's in the notes there.
Trying to look for that.
Paragraph 1.
Yep, it's that
On
just the
section
beginning
2.
there.
Okay.
So you wouldn't be potentially discriminating against someone for who they are, but for what they stand for.
Right. Okay. And his suggested fix here, I'm assuming this is Julio's words, is the insertion of that might speak to his concerns. Respect constitutional rights of all.
Well, he thought that should be added in general. But so I don't know if that was in place of.
Okay.
But he just thought, he basically just said he wanted to point out to the committee that, and granted, he did also recognize that or any other protected characteristic under law would cover that. So, even including one of those, including but not limited to the list, but we do have the catch-all at the end. And he recognized that, if we had that scenario come up, we could address it. He was just pointing out that we were lacking that type of discrimination, which kind of brings us back full circle to, would we want to simplify it to say, biased treatment, treating someone differently because of, and then it's the because of. And if there's a simpler phrase instead of having, the list. But then again, to Karen's point, it's important for folks. We don't always know if folks know all the protected classes.
Right. Mark?
So I don't, and without the explanation, and I'm not sure that everyone would get the explanation, I don't know that I would understand what viewpoint or content discrimination or protected activities bias is if I were a brand new person coming into this. So I'm concerned from a training concept of how do we explain this to people. That would need to be possible. I'm also concerned with shall respect the constitutional rights of all, because number one, that is part of the oath of office in maybe different language. But number two, there's already legal constructs in play during at least criminal law enforcement, and the attorneys could probably speak to other things. But a story I use is when I was a new deputy, I stopped a guy. He had marijuana that was wrapped in a paper towel, and I opened the paper towel, and the court ruled it was an unlawful search and seizure because I had no right to open the container. To me, it was a paper towel, it wasn't a container, but I violated his Fourth Amendment or 11th Amendment right which then I would read that as a law enforcement officer, that any time a fruit of the poisonous tree case came up, that they have actually committed category B misconduct, when that was nothing more than a paper towel's a container. What if it was a ripped paper towel and I could see through? Like, it's, so I just get concerned that we have a circle of wagons to try to handle this discrimination issue, and we're trying to explain it to people who are going to read this and ideally read it frequently, but at the same time, I think we're going to deal with cases where they don't read it frequently, and it was just not malicious intent. It was, that's what that meant.
And I think there's some benefit in having it at least very similar to the FIP. And if we deviate from that, we've got a whole new channel. Mike?
I'm thinking very similar to Mark. Our goal here is to effectively put everybody on notice of what is the prohibited conduct, and I think spelling out very clearly like we have may be the best way to do that.
Who's next? Jim?
Well, let me defer to Tucker, who's probably much more eloquent than I am. In fact, he is. He's probably got a point that I'll just agree with.
That's
Tucker, see how I
dangerous.
did that?
Yeah. Actually, I was just gonna. Mark already said it, which is that the constitutional rights issue is a concerning standard to me, because almost every suppression hearing I did regarded whether or not an officer violates someone's constitutional rights, and it was never about misconduct. It was really just often Article 11 fights after the fact. So I wouldn't want to make that the standard. Everyone's got to adhere to FIP. There's consensus that a FIP violation would fall under this code of conduct under a policy violation of the council. Kim, is that the case?
It's a statewide policy, so it would fall under the new definition, well, the old definition and the new definition. We would still, any FIP violation would be a category B.
Right.
Complaint.
On its own. Yeah.
Yeah. And the only thing I'd say is this discrimination definition makes a lot more sense when you realize that what we're focusing on is, in addition to FIP, off-duty conduct that also satisfies a discrimination or bias thing. And we'd almost, I'm not sure if it would be helpful to clarify that, to say that this is what we mean really when we're talking about discrimination, is when it's off duty, it's this level of scrutiny. And otherwise, it seems that FIP would cover that personal characteristic discrimination, that on duty that we're focused on there. It's the distinction that might be worth. But I do think this kind of covers it in the sense that that's what we were getting at. So no, Jim, that wasn't very eloquent, and you go ahead and say it better.
Yeah, don't say what he said, because I'm still trying to figure out what he said. So
sorry.
You've done better, Tucker. I'm just going to say that. In reflecting and listening to the conversation, I think we were very deliberate reviewing and creating this. And maybe it's just because of the position and how immersed we've all been, but for me, our work on this number 2 discrimination feels clear, and at times more precise than maybe what we've discussed in the last 10-15 minutes. And that may be just a factor of me being completely immersed in this, but I would want a trooper to be able to go to this and understand it on the first read, and to me it does that.
I think that's why I like the specific calling out of these characteristics. I don't,
Yes.
if it's, under law, it's like, well, what does the law say? And I think we'll find that you can't go to just one place. It's all over the place that these are immersed into different laws. Frankly, and I don't want to stymie discussion, I don't want to devalue any comments, but, I don't necessarily have a problem with the original writing. I'm not sure Julie's got stuck in the middle here or policy. I think that we've already got policy covered, in the law itself elsewhere. I think that I've heard enough on the final statement to personally not want that in there. Kim, you're throwing in an 11th hour or something here. So what are you putting in here?
No. It's only to, I know you all read the FIT policy on a daily basis. You just sit there
okay.
and roll through it. But
Gotcha.
I just, for my own sake, because I actually have read every department's FIT policy for the last 3 weeks, I've been reading them. I just wanted to pull out that, first page in the FIT policy, prohibited from engaging in bias policing. Like that's right. That's the big sentence there. So only to bolster what you all have said, that some things that may not, if they slip outside of this discrimination clause in our code of conduct, potentially the FIT policy is going to be there if, if somebody is engaged in bias policing, whatever that might be.
Which is a robust stakeholder created policy. So we would hope that it encompasses what everybody agreed upon at the time. So do we have thoughts? I know lots of individual thoughts. Do we try to keep the hood open and tinker with number 2, or do we just accept what we have and move on?
Can I just be clear, Trevor? I want to see what the consensus is on the last added sentence, on whether that's to be included or excluded. The consensus from this group.
I don't like it.
I don't think it needs to be there. Yeah.
No.
Consensus is not. Don't accept that
Okay.
recommendation. Yeah. But I haven't called for, I don't have consensus on, do we try to tinker with number 2? Or do we just feel good we had conversation, we revisited it and move on? I'm personally good to move on.
I am.
I agree. I
I'm
think
good to
it's
move on.
Good
Yep.
to move on.
Trevor, do you mean moving on as in let's just move on to the next one? Are we accepting this as written sans the last sentence? I'm not sure what you're asking.
Yes, that's what I'm asking is, are we okay to move forward from its original version? So not striking course of conduct, leaving in course of conduct, leaving in single or egregious, not adding policy, and not adding the final sentence. So original as originally written. That's what I'm asking. Are we okay with that?
Yes.
That was easy. Okay, so misuse of official position. I don't know if this is Julie. Again, the blue is Julie's added. And did something get, what was the original? I shall not misuse my official position for personal economic gain. Is that all it was?
I think that was copy and pasted from the statute and just written in the I format. So we took the
Okay.
legislative intent there.
Yeah,
think it was
the original Trevor, there's just an or.
Yeah.
That got struck out in Julie's, but yeah, I shall not misuse my official position for personal or economic gain. I appreciate Julie's additions, but I don't think we need them. I think our sentence captures all of that. for our purposes, but I understand
Yeah,
why
no.
she put that in.
And I'm fine with the original verbiage as well.
I am too.
Okay. The DV section, I think here, she's not privy to, the legal definitions that we're accustomed to in statute, which I think originally is why it was written the way it was. She perhaps puts it in a little more plain English, but I don't want to confuse our folks with deviating from statutory language.
Agreed.
Yeah, totally agree.
So that being the case, we can move on from that. And then sexual misconduct. So she actually narrows the resources in the beginning. Well, no, it says official resources. She's rewording it to law enforcement or municipal. I think official gives more latitude. She does add harassment stalking. I don't know if I don't recall if we discussed that or not.
I don't know that I like the first two changes.
I think official position would cover those changes. If
Yeah.
you're through your position, you're using resources, that's already covered.
And if you say use my position, what position are we speaking of? That's, to me, I want to be clear that this is the law enforcement position. So I like official there. I mean, I think resources is well, official resources is maybe a little broader than law enforcement resources. And if it's already passed muster with some stakeholder groups being, in my mind, more broad, I think that's fine. And harassment, I go back to some of Mike's comments continue to ring true, is that this isn't sexual harassment. She's just got harassment. I think that's an internal issue. That's departments need to handle that. I don't know that should be dealt with in a certification standard. I mean, we've got
Stalking would be covered in the domestic violence portion, right?
Should be.
In statute.
Mhm.
TV. Oh, okay.
Also under criminal conduct.
And not violate the policy. And I'm going to be certain that our policy talks about you can't stalk people. And so that clarifies that. Then we've got online. She added online and virtual. I think why isn't online verbal or auditory written? I think that's just adding different ways to say perhaps what's already there, unless somebody sees a need to add it.
I think it's similar to my comment earlier that
Yeah.
at this point in time, online or virtual would be already considered.
Yeah.
Mhm.
Okay. We've got bribes or job conduct. That narrows it.
Sorry, Trevor, can we go back to 7 real quick? Like, where are we? So are we?
I think we're not
going
considering any of them.
Okay.
Or as originally written. Yeah. Well, here too, though, we've got on and off duty conduct, right? So I'm afraid job might confuse that a bit.
If we're going to talk about conduct, I guess the question is, should that be official conduct? I'm not sure what job conduct would actually mean. I mean, is our intent that we're talking about official conduct?
Yeah, I agree with that.
Yeah, I mean, is this a time to put that in because, solicit
Yeah,
item? I mean, if I browbeat you for a case of beer so that I'll mow your lawn, I'm not sure that we want to be considering that. Yeah.
Yep.
Yeah, so this may be an opportunity to, I think that makes sense to insert, instead of job, insert official conduct. We're good with that?
I'm trying to think through. Our original version was judgment or conduct, period, right?
Period. Yep. No. Yep.
Does official conduct exclude conduct under color of law?
I think I would, I'm no lawyer. I'll look at the lawyers. I would consider under color of law to be official. It's your official capacity if you're under the color of law. The lawyers are notably silent.
Well, I'm just wondering, we've taken that language out of category B, the definition. So I'm wondering what example are you thinking, Mark?
I don't know that I can think of an example. I mean, Trevor's scenario, browbeating someone for mowing the lawn for a case of beer. I mean, I don't think anyone would consider that to be appropriate, but just saying it's official conduct, agency says, well, we're not reporting it because that wasn't official conduct. It was inappropriate conduct. I don't know. I'm just. Does the introduction of official narrow versus not narrow?
The conduct should be related to your duties. So I think conduct is too broad. Is official the right word? I'm not sure, but I think it gets there.
I mean, I do agree, Mark. I think it narrows, but I think it justifiably narrows. Because
I'm
we've
okay
been
with
very
that. I just
clear.
want to be
Yeah.
intentional on it.
Yeah.
Mhm.
Yeah.
I'm not proposing a change, just a thought, but I'm
Yeah.
good to move on.
I mean, I'm fine with official. I don't know if that's the consensus or if the consensus is to leave it as original.
yeah, I like official.
I'm in favor of official. We have consensus, yeah.
As a
Okay.
mind, yes.
All right. Okay. And so that brings us to the last one. And frankly, I'm intrigued by the addition to this one. Many of them I've kind of, looked beyond, but, is assist in, does that broaden this and justifiably broaden it?
I think it does.
And is it something we want to do? I mean, I like it. I think it's something I didn't think about at the time. If you're helping somebody else cheat, that's tantamount to cheating yourself. And I do think that's something that should be in our purview.
I'm trying to think how assist in would be different than furnish.
Furnish, you're giving somebody the answers ahead of time, assisting, hey, look at my paper while you're sitting next to me.
But that's still furnishing.
I think I
mean,
could
it's-
capture that and furnish, yeah.
Do you think so?
Confirm.
Okay. Yeah.
Well, it's interesting.
But I'm intrigued, Trevor, because I'm also wondering, is there a way you can assist without furnishing?
Mhm.
Hey, the answer key is under the teacher's desk. I didn't give you anything, but I let you know where to look.
I mean, so I think maybe for the case for me, again, I'm very visual, is that I think that this is more an in your face. hey, furnishing, it's what does furnishing mean? It's, I handed you the answers versus assist in means I'm not going to tap on the desk. I'm not going to send you a text. I think assist in is just a little more crisp, a little more in your face that, hey, you can't do anything to help somebody else in an unethical manner. Maybe furnishing means the same, and that's fine. I personally like the more stark, really jumps out at me.
I can think of a real life example. It actually happened in New Hampshire. I know an officer there. They have a mandatory physical fitness test. And there was someone that assisted in one of the people cheating on the physical fitness test. It wasn't providing answers. It's not always a written exam we may be talking about. And we do have physical fitness testing, and we could have the same example occur here.
So you've got to do.
Did they carry them? How did they assist them?
They knew that he was cheating on how far he was supposed to run and went along with it.
And I think we buddy up, and you've got to do 30 push-ups in a minute, and you only do 28, and your buddy writes 30 on the list. Yeah.
Oh, and especially as we talk about distance learning, if there's testing capabilities online, if I take Trevor's test, I'm assisting without furnishing or obtaining. I like it.
I think it provides more clarity. It's another way again, like you said, Trevor, it focuses people on no assisting. Everyone can track that.
Yeah. Are we good by consensus? Assist in? If I head nod, that means yes.
Yep.
Trevor,
So,
I know
Kim,
everybody's looking
ahead.
at the clock.
Yep.
One thing that wasn't on Julie's edits, and it wasn't on the other note